think I've always kind of had a social justice background. The clients we deal with face many, barriers to justice. Access to justice is, it's expensive to get a lawyer for criminal matters. So, people who we do represent don't actually pay any money for our services. So if they meet our intake criteria, then we can offer our services for free, and that's what we're funded to do. So that was a big part of it. Access to justice is a huge barrier for people with not much money, as well as people suffering from severe mental health illnesses as well. So that's essentially, I think, one of the draw cards for me. And also, I think I do like being in court as well. It's good fun, surprisingly. But yeah, that was also partially one of the reasons why I wanted to work there as well.
What did you find most challenging in the side of the mental health combined with the law? Like, what is the most challenging thing for you?
Well, the law that we deal with in particular probably isn't very complex. I think it's pretty fair to say that the most challenging thing we deal with is probably client management, because our clients can be very unwell, and to the point that they're hospitalised essentially. So we do have quite a few different challenges in relation to that. Sometimes it is difficult just to get instructions from your client. So you really, as a lawyer, you can only act on what your client's telling you. Sometimes it's hard to really just even get those instructions. So yeah, that's definitely a difficult part of it. And it makes it easier, I guess, when you're working with social workers and mental health workers as well. It makes it really good if you've got those referral pathways set up, ready to go. So essentially what I'm going to be running through today is what we do as a law centre, focusing on the particular areas of law that we cover, that we specialise in. But I'll also be letting you know a little bit about the referral pathways, how you can refer clients to us, and the processes that we involve in terms of that. First of all, I'd like to begin by acknowledging the traditional custodians of the land which we meet on, and pay respects to their elders past, present and emerging. So as I said before, today this is what we're going to be focusing on, and these are the areas of practice that we as a law centre specialise in. So that's criminal law, restraining orders, mental health tribunals, guardianship and administration matters, and we do mentally impaired accused review board and care and protection matters. I'm not going to touch on them too much, generally because the referral processes for those are a bit different, and we don't really come across too many of those. We have actually just opened up a care and protection service that we've employed some new lawyers in, and that's kind of its own separate thing, separate to the Mental Health Law Centre. Very valuable service they're offering. So essentially what I will be covering is how we can best work together in the future, be that social workers or mental health professionals, referral processes, and then at the end, if you have any questions for me, we can have a question time at the end. So this is who we are, the Mental Health Law Centre. We were established in 1997. We've been running pretty much since then. We've expanded the practice quite a bit. We were originally in Northbridge. We've now moved to Subiaco. We've merged with Rua Community Services, so we're working alongside them as well. In terms of our team at the centre, we have a group of lawyers, so we've got 8 lawyers at the moment, and we practice across all those different practice areas. We've got a team of volunteer paralegals who man the advice line, so any calls that come through to our centre generally answered by the paralegals, so they're all volunteers, usually law students who are volunteering about 1 day a week. We've also got a team of social workers who we work alongside with as well as the admin team. So as you can see there, our advice lines are open from 9 till 4 p.m. Weekdays. So we do offer legal representation, but we also have a service for advice as well. So if we have clients calling in who perhaps don't have a matter in court or there's a tribunal, but they do want some legal advice in relation to some of the services that we offer, then that's something we can facilitate as well. So legal representation more related to, in-court representation, whereas advice can be a one-off service where a client just calls in, talks to the lawyer. So predominantly we'd give advice in relation to the aspects of the law that we deal with, which were mentioned before. So we do have an eligibility criteria for legal representation, and that is what's listed there. So first and foremost, our clients need to have a diagnosed mental illness. Secondly, probably more in relation to the criminal matter, their legal issue has to be causally related to their mental illness. In terms of things like mental health tribunals, which I'll probably discuss a little bit later, and guardianship and administration, their mental illness is already really related to their legal matter, so it's not really an issue that's in dispute. But certainly for criminal matters, it is helpful to know if there is a causal link between their mental illness and any kind of alleged offending. Thirdly, that they have a legal issue which falls within our expertise and our services. And finally, we do have a financial hardship criteria. So if they do have the ability to pay for a private lawyer, then generally they won't fall into our criteria. It's also dependent on whether or not we do have capacity. There's no conflicts of interest. And there is, in terms of merits reviews for reviewing trials and going to trials, we do have a merits review process, which I'll talk about a little bit further on. So as I touched on before, we do offer one-off legal advices in relation to a variety of different things. These are some of the common ones that come up in terms of people calling into our advice line. So it can generally be anything from freedom of information requests, people wanting their medical documents from a mental health care provider. So we can give advice on the processes in terms of that, as well as information. We can't really assist them in doing the FOI request. Unfortunately, we just don't have the capacity to do that. So that essentially covers most of what we can do in terms of advice. So I'll now kind of go in a little bit more detail about the type of services we do offer in terms of representation. So like I said before, the real big one that we have is criminal law. So this is probably the representation that our lawyers spend the most amount of time on. So we provide free confidential legal representation in terms of criminal law matters, mostly in the magistrate's court. So that's what's called the summary jurisdiction. And so we assist clients with initial hearings, bail applications, sentencings, and a variety of other procedures in the magistrate's court. Just to keep in mind, if someone is wanting to refer a client to us for a criminal matter and they do have a hearing, generally we'd require about 10 days working notice. It just allows us to get all the documents from the police or from the other parties, and those processes do take some time. So if someone does contact us and it's within that notice period, we'll generally advise them to seek an adjournment. So there are duty lawyers down at the Magistrates Court from Legal Aid who can help people out in seeking adjournments, particularly if they let them know that they're in contact with us, they want our representation, but they just haven't had the time to contact us. And generally magistrates in the courts are pretty lenient in terms of giving adjournments, particularly if it's if the client's looking for legal advice. As I touched on before, the eligibility criteria is what was up on the slides before. We do try and prioritise people on involuntary treatment orders. So that's mental health treatment orders in a hospital or in the community. And I'll touch on them in a bit more detail when we talk about what we do in terms of representation for those clients. And like I said before, we will mostly do magistrates court matters. We'll do sentencings in the district court. Unfortunately, just because of capacity and resources, we don't have enough lawyers to run trials in the district court, so that's trial by jury. We just don't have the resources to dedicate to those quite lengthy matters. So in terms of common situations that often our clients find themselves in, sometimes they're arrested on suspicion of a particular charge. They're arrested by the police, taken in for a police interview. So they'll call us, and that's where we can give them some one-off advice in terms of what to say in a police interview, how to conduct themselves, we can do that. However, we can't actually get involved in terms of representation until there's paperwork from the courts and from the police that confirms that they have actually been charged. So sometimes the police will get someone in for an interview and won't charge them as a result of that. So that's why we need that confirmation from the courts. And this is a very good website, eCourts. It's a publicly available website. You can log on to that, and if you do in the future have a client who you think may have a charge, you can put their name in and it'll show up any of their current active criminal court appearances. So it is useful for really anyone, and it is publicly available. So once they have been formally charged, what they'll get is a lot of these documents. So they'll get most of them from the police. There'll be a prosecution notice, which sets out, the offence, what's alleged to have occurred. They'll have a statement of material facts, which is what the police are alleging occurred, essentially, their record of events. And there'll be either a court hearing notice or a summons, electronic record of interview if that's occurred, criminal record, and some other documents as well, possibly, depending on what court it comes from. So we try and get all of them. If you're working with a support person, sometimes they have that and send it through to us, and that's very helpful. It usually means we don't then have to make an application to get it from either the courts or the prosecuting services. So this is an example of what a prosecution notice is, just in case you do come in contact with these in the future. So it essentially just sets out the details of the charge, what court it's in, when it was lodged, the name of the person, and the written law, which is what legislation they're alleging to have breached. So that's what that looks like. It's always helpful for that to be sent through to us. It does help us out a lot. Depending on what kind of document is issued to the client, it's important to understand that sometimes they don't have to attend court at all. They can, if they're on a notice, just write into the court to say that, if they plead guilty, they plead guilty, and they just wanting to get it over and done with. They can just send that into the court, and then it'll be dealt with in their absence. They'll get a conviction on their record. Generally, that will only occur for very minor offences. If they're on a summons, it does require them to be in court. So that will generally be issued to a person by the police after they've been charged, and it does require that they appear in court on that whatever date is specified. And so if that's the case, it's always important to seek legal advice in terms of where they can go with the charges, whether or not it's a plea of guilty or not guilty. So if people are unable to attend a court, they've obviously got to have reason to do so, whether that's, they're in hospital, or generally it's mostly that they're in hospital. It's pretty tough to convince a magistrate that, they have reasonable cause otherwise, unless they are very unwell. You need documentation to back that up. So obviously medical documents is probably the best way to prove that someone had a reasonable excuse to miss court. And, if you do present that, then the magistrates are pretty lenient in terms of granting an adjournment. We do also offer, honestly, it depends. I've seen someone have like 17 adjournments, and it just well, probably not years, but it's just very dependent on the circumstances of the client. Like, and sometimes magistrates will get onto your first appearance being like, you've got to put in a plea, or it is very dependent on what court it is and what the magistrate, is essentially feeling on the day, really. So it is wildly, disproportionate as to what happens there. This is a type of application we can do. If someone, say, was in hospital at the time, and they did have a court appearance, and then the magistrate sentenced them in their absence, it was a minor charge, we can make an application to have the charge come back before the court. And in those circumstances, we'd obviously present medical evidence to say that, they were in hospital at the time. They didn't receive notice of the court, or, they didn't receive notice in enough time, or they had a reasonable, a good reason for not attending court. So that essentially would be bringing the charge back and then having it proceed with legal representation. So that's also something we can do. We do get a lot of people in hospital wanting us to make these applications, and we've done quite a few of them in the past. So in terms of the process for entering a plea, or prior to entering a plea, like I said, an adjournment is usually granted, a couple of adjournments usually granted for legal advice. When we represent clients, we try to negotiate with the police as much as possible to get charges either dropped or discontinued, and we rely on medical evidence and the instructions from our client to do that. That's essentially one of the services that we offer as well. You can obviously enter a plea, the client can enter a plea of guilty or not guilty at any time. Ultimately, it's up to their instructions as to whether or not, what way they go. Obviously, bail. Bail's something that we deal with all the time. We do a lot of bail applications for people who have had their bail revoked. And obviously bail is a written promise essentially to come back to court. Sometimes it'll have conditions on it, like protective bail conditions that will prevent people from going into certain areas or from contacting people. So it's also, if you are ever dealing with clients in the future, it is important to know what their bail conditions are, because you can be charged with a breach of bail if you do breach any of the conditions that are imposed by the court. So when people are entering pleas of guilty, it's important to understand that that's an acceptance of the elements of the offence as well as the statement of material facts that's provided. So that's where we come in, obviously, giving advice in relation to the appropriateness of a plea, of defences to a certain charge, because it's very difficult to change a plea of guilty to one of not guilty, whereas it's very easy to do the other way around. And once you've entered that plea, it generally goes to a sentencing. It can be put off for reports to be produced depending on the severity of the offence. So these are just the potential sentencing outcomes. I'm sure you're probably all aware of what can happen if you found guilty and it goes to sentencing. It can range from no sentence to a community-based order to imprisonment, really, depending on obviously the severity of the offence that you've been charged with. So there are diversionary programs in court, which I'm sure probably not a lot of people realise. So there's things like Start Court, Drug Court, the IDDP program, which is the Intellectual Disability Diversion Program, as well as the Family Violence Court, which are trying to make a court a little bit more of a therapeutic approach, particularly in terms of Start Court. So Start Court is a specialist mental health court in the Perth Magistrates Court. So its main goal is to, people who do have serious mental illnesses and they do commit these offences and they're pleading guilty, they can be put on this Start Court program, and essentially it attempts to put in place supports, so with that social supports, mental health treatment, put that in place over the course of around about 6 months prior to a sentencing date, which they call graduation. So they put all of that in place, and then the client is sentenced, and it's essentially meant to be a therapeutic approach that encourages people to not be caught up in the justice system, and give them skills to obviously progress in their lives. So we deal a lot with clients in Start Court, and it's a very good program. So the process really starts with a referral from the generalist, so from any metropolitan court in Perth. You can be referred to the Start Court. You obviously do have to have a diagnosed mental illness. You do have to be eligible for bail. And it is quite an intense program. So although it is voluntary, there is a lot of program requirements that go on with it. But if you do complete it and you do really well, then it reflects very well in sentencing. And I've seen clients who have got really, really good results out of that. And that's also with the social supports that get set up as a result of it as well. So it's very worthwhile if the client is willing to, take the time and the effort to go through the program itself. So as I said before, that's the kind of considerations they take into. If it is very, very serious offending, generally Start Court won't accept a client for the program, particularly when there is a likelihood of imprisonment. It's just one of their intake guidelines. So for a plea of not guilty, that's essentially the client disagreeing with the statement of material facts and wanting to take that matter to trial. We do assist in trials. What we need to do first is make sure that this is the appropriate way for the matter to proceed, if there is any defences available and if there is merit to take the matter to a trial, and that's purely based on our capacity. Like I said before, it is quite a drain on resources taking matters to trial, so we do need to do a merits review before that to review all of the evidence and make sure that's the appropriate resolution to the matter. So in terms of any kind of referral process for criminal matters, it's always important that, if you do become aware of a charge that a client has, just refer it straight to us. Now we've got the telephone line which runs from 9 till 4. Just call up with a client, and it's always good if they do have a support person with them, because it makes it much easier for us to get all the information from them as well. That essentially, if they've got all the documents there, then we can pretty much do an intake straight away. So it helps us out a lot. As I touched on very briefly at the start, we do act for clients in terms of the Mentally Impaired Accused Review Board. That's essentially where people have been found unfit to stand trial, or they've been acquitted of their charge due to unsoundness of mind. They're essentially, for these serious offences, placed on a custody order, which is an indefinite term of detention. So the Mentally Impaired Accused Review Board is reviewing that reviewing the custody order every 6 months. So we do appearances at that. Generally, we don't get referrals from community workers or mental health professionals in terms of that, because these people are on these custody orders, and usually they're in prison. So we usually get referred that by the board itself. We do act in terms of restraining orders as well. So we can assist with respondents in restraining order matters. So the person who's making the application for the restraining order, they're known as the applicant. The person who's then subject to the restraining order is the respondent. So we only act for the respondent, and they once again obviously have to fit in with our intake criteria as well. So that has a 10-day working notice as well. We're trying to prioritise people who are particularly unwell, and you've got the 3 types of restraining orders. So obviously violence restraining order, family violence restraining order, which are used when there is a family relationship, and misconduct restraining orders. We don't really deal with misconduct restraining orders too much. Just in terms of our capacity, we tend to try and focus mainly on VROs and FVROs due to the seriousness of the breaches in terms of them. So essentially, for someone to get a restraining order, all they really need to do is go to court, and they make the application in front of a magistrate. And the other party isn't here at this point in time, so they'll allege what occurred, the violence, and if the magistrate's satisfied that an order's in place, then they'll put in place an interim order, which will then be served on the respondent. And the interim order is essentially the same terms as the final VRO. So if they breach any of those terms, then they're looking at charges which will be heard in court. And those conditions can sometimes be, don't be within 10 metres of someone, or don't communicate with someone else. Yeah, look, I think they are effective. I think one of the issues I have with them is that, particularly with the clients we deal with, they don't understand what a breach is some of the time. So say they get a phone call from the protected person. If they pick that up, that's a breach, particularly if they have a don't communicate clause in it. So it makes it very difficult. So you can rack up, our clients can rack up a lot of breaches just because they don't really understand. Responding to a text message or something like that, that's a breach. So that's one of the issues I think I find with them, particularly with our clients. They just tend not to understand, what breaching the order is, and I think it can cause some issues with us, because if you are charged with 3 breaches that occurred on 3 separate days, there's the assumption of imprisonment as a sentence. So it is very serious matters. So that's why we...
Why would they respond to texting them in the first place?
Well, it's the protected person, so the applicant would be texting them.
Sorry,
Yeah.
So why would they text them?
To get them to breach the order. Yeah, it can happen all the time, yeah. Especially in family violence restraining orders, so it can often be the partner, you know, and it's not, they could be communicating about your kids or finances or something like that, and yep, you can be charged with a breach for replying to a... So often what we'll be advising is just to delete the numbers, and then that's when we come in terms of once the interim order has been served on the client, they've got 28 days to essentially object to the order, otherwise it becomes final. So in terms of any referrals for that, it's very time sensitive. So as soon as they've been served the paperwork for the VRO, which generally happens, the police will give you the paperwork, and that's service. And that can happen when clients are in hospital as well. Yep.
Sorry, I want to finish. Very quick question. Why only respondents? Why not the one that are applying the application?
Yeah.
They're going through, you know, all these things.
Yeah. Well, in terms of that, it is mostly due to our capacity as well. And there are quite a few services that already act for applicants in relation to restraining order matters. So yeah, we tend to try and only focus on respondents for that reason. And like I said, it is very time sensitive. So if ever you're dealing with restraining order matters and the client does have has been served that, it's important to get legal advice ASAP, because if they're wanting to object to the order, they only have 28 days to do that, to get that paperwork in. So it's important to facilitate referrals as soon as possible. So we obviously do restraining orders. We also, majority of our file load in terms of how many files we get and how many clients we come through are mental health tribunal matters. And mental health tribunals are essentially, it's a tribunal that's set up to review people's involuntary treatment orders. An involuntary treatment order is essentially a psychiatrist will assess someone who is particularly unwell at that point in time. And if they believe that they're in need of involuntary treatment, they'll make one of these orders. And it's essentially, there's 2. There's a community treatment order and an involuntary inpatient treatment order. So the only difference is, as an inpatient treatment order, you have to be in hospital. You can't leave. You're receiving treatment against your will, essentially. So that's why the mental health tribunal is here, to review the psychiatrist's decision, to make sure that all of the appropriate processes are being made. So this is the criteria for an inpatient treatment order. So most of the time a client will get taken into hospital because they're very unwell, and then they'll be assessed by a psychiatrist who assesses them in light of this criteria. So firstly, that they have a mental illness that requires treatment. Secondly, that there's risk to the health and safety of themselves or another person, or there's significant risk of serious harm to someone, to themselves or another person. Thirdly, that they don't have capacity to demonstrate treatment decisions in relation to their mental health. And the final 2 are that they can't be treated in the community, and that there's no less restrictive way to provide treatment. Because often you'll find that people are so unwell that they don't want to take their medication, and they don't want to engage in treatment. They don't believe they have a mental illness. So, you know, then forms that, you know, maybe they're a danger to themselves or other people, and that's why they're then put on these kind of treatment orders. So they are very restrictive, and that's why the mental health tribunal is there to essentially make sure the psychiatrist is you know, ticking all the boxes. And where we come in is we obviously assist the clients at the tribunal, so we'll take instructions based on what they're saying in terms of the criteria as well. And we'll help them out in the hearing. And this is the criteria for the community treatment order, pretty much exactly the same, except the only differences is that there's a significant risk of serious physical or deterioration, and they can also be treated in the community. So that's the differences in terms of the two treatment orders. Obviously, one being inpatient, where they're in hospital, the second being community, when they're can be treated in the community. So in terms of processes of this, if they've been put on one of these orders, they have 35 days before, they have a period, which is 35 days, in which a mental health tribunal will be scheduled. That'll essentially determine whether or not they need to continue on with that kind of treatment order. The only other way for them to be discharged of these orders is for the treating team, so the psychiatrist, to then obviously have a look at the criteria before, make an assessment of the client and determine that they don't meet that criteria. Then that means they'd be discharged of the order. If there is a child on one of these orders, it is 10 days instead of 35. So it's just important to keep that in mind. So generally what happens is they'll be put on these orders, they'll call us up, or one of the mental health support staff will give us a call saying that one of the clients has been put on these orders, and then they can have a chat with a lawyer or a paralegal, do the intake. We generally give them a call to let them know about their rights on the inpatient treatment order or the community treatment order. And then if they do get a hearing set after that, then we'll offer representation at that hearing. So depending on what the outcome of the hearing is, the mental health tribunal is essentially 3 members. So it's a community member, a psychiatric member, and a legal member, and they make a decision based on the instructions from the client, as well as submissions from the treating team. So based on that, whether or not they then make the determination that the client still fits the criteria for a treatment order, they may maintain the order, they may think that they don't meet the criteria, so then they'll discharge the order. Or they may, in the case of an inpatient treatment order, if they think that the only risk present is one of deterioration and they can still be treated in the community, then they'll make a community treatment order. So appeals can occur if the client feels like that there was an incorrect application of the law. They go to the State Administrative Tribunal. We don't really get too many of these, mostly because the State Administrative Tribunal will only ever determine an appeal if the treatment order is currently still in place. So generally what happens is the MHT will maintain the order, and then if it is contentious, they'll probably get discharged a couple of days later anyway. So then the State Administrative Tribunal doesn't have jurisdiction to hear an appeal on that matter. So it is a bit frustrating. It just means that there's not really any precedence in this area of law. So it can get a little bit frustrating for us in terms of procedural fairness. So in terms of providing support for MHTs, like I said before, we get a lot of calls from social workers and mental health support staff who are supporting the clients in the involuntary treatment order, because a lot of the time the clients are very distressed. They're not really sure what's going on. So it's important that we can give them some advice, let them know of their rights, and facilitate the process of getting representation at a mental health tribunal. So we work quite closely with the Mental Health Advocacy Service as well. We have a good working relationship with them. They also do representation at mental health tribunals as well, but they're kind of focusing more on the advocacy side of it, whereas we tend to focus on the legal criteria. So there is a bit of a difference there, but we offer, possibly a similar service. We also do offer representation in terms of guardianship and administration. So I'm not sure if anyone knows too much about what this is, but these are matters that are heard at the State Administrative Tribunal. Now, in terms of a guardian, so there may be someone who is so unwell that they need a substitute decision maker around personal lifestyle and treatment decisions. And that's where a guardianship order will be applied for. It tends to be applied for by hospital staff or the hospital itself when they have someone, say, on an inpatient treatment order and they are very unwell and they have concerns around whether or not they're going to be able to manage decisions around accommodation, lifestyle and treatment when they are discharged. So that's why they make an application for these orders. So this is the criteria for a guardianship order. The person obviously must be over the age of 18. They've got to be incapable of looking after their own health and safety, unable to make reasonable judgments in respect of matters related to the person, and in need of oversight, care and control in the interests of their own health and safety.
There is two guardianships, so there is one for financial and there is one for mental health, yes?
So a guardianship is in terms of personal decision making. I think what you're talking about is probably an administration order, which is, I'll touch on, that's to do with, finances, so financial decision making. So that's the statutory criteria for it. And it can really encompass a lot of different things. So what will happen is in the hearing, you'll have submissions made by the treating team and sometimes social workers as well, saying that these orders are in the best interest for the client, and they're not able to look after their own health and safety. They can't make reasonable judgments in relating to their own person. And if they were to be discharged without appropriate supports, then they wouldn't be making decisions in their best interest. Similar with the inpatient and community treatment orders, they are very restrictive on clients, and they don't particularly like them being applied for on their behalf. So that's where we come in. We can come and sit down with the client, go through all of the reports being provided, take instructions, and represent them at a guardianship hearing. So this is just who can be appointed as a guardian. Obviously must be over the age of 18, and they have to have consent to act from the state administrative tribunal. So they can make decisions in relation to accommodation, so where and with whom to live, in relation to where the represented person can work, what services they're involved in, where they're educated, with whom they associate. They can also make decisions in relation to legal matters as well. It can really be quite restrictive on the represented person. So it's always important that if there is any consideration of guardianship orders, that someone does refer the client to us, because we can obviously go through that with them as well. And we do get a lot of referrals from the applicant for these orders as well, so social workers and stuff. They obviously realise that the client does need legal advice, and they're usually more than happy to make that referral to us. And this is what you were talking about before, the administration order. So it's essentially very similar to a guardianship order. It's just in relation to decisions around someone's finances and estate. So like I said, very restrictive on the client. It essentially can be, if it is a plenary order, so that means it's then the administrator is in charge of all financial decisions. It can be very restrictive for the client. So this is the statutory criteria for that. They've got to be unable by reason of mental disability to make reasonable judgments in relation to their estate. In terms of who can be appointed as administrator, it can be an individual or a trustee over the age of 18. Generally, in my experience, it's mostly the public public trustee. So they operate most of the administration orders, and they manage the finances of the person. So in terms of process, the application's usually lodged, and that's generally when it's the best time for the client to contact us. They might be aware of the application, they might not be. There might be hearing dates set, there might not be. So it's important just to get in contact with us to facilitate the referral really as soon as possible. And then when the hearing comes around, obviously it's usually before a single member, and that's where we would assist the client with putting forward their instructions and addressing any legal issues in relation to the creation of either guardianship or administration matters. So orders can be made for a maximum period of 5 years, and they're automatically reviewed by the SAT on whatever date they prescribe for that order. Appeals can be made to the State Administrative Tribunal. It then goes to a full tribunal of 3 members, and that would be in circumstances where there was an error of law or there was an error in the decision making to appoint either a guardianship or administration order. Also, individuals who are subject to either guardianship or administration orders can apply to the tribunal for an early review. Say if it's been set for 3 years and they want to review after 1, they can do that. They just need to show a change of circumstances, and so something that's changed since the original hearing, and that can be, that they're now managing their funds a bit better through budgeting, or they're starting to make decisions around treatment in a more appropriate fashion. It can really be a variety of different things. So as I said, this can be a very distressing time for the clients. It's essentially having really all of their decision-making power taken away from them. So it's important to keep that in mind when you're dealing with these clients, because it can be a very distressing time for them, and they can get quite confused about the roles of what a guardian does and what an administrator does. So it's important to be clear and explain the processes to them really as best as possible. A lot of the time we do get applications where there is a lot of medical evidence that is suggestive that guardianship and administration orders are in a client's best interest. So look, what we try and do is present situations where there can be oversight and care, but perhaps with a less restrictive manner. So that's often what we're putting forward to the tribunal. So if you are wanting any further information on any of those orders, it's definitely worth checking out. I think these are a couple of YouTube videos that we actually did. They're available on our website, so I probably won't play them now, but definitely worth checking out if you're wanting a bit more of information, particularly around the processes involved. So as I said before, we do have a care and protection. Oh, not a problem at all. Yeah, no worries. We do have a care and protection team that's only just started working with us, I believe, at the end of last year. So they're offering support to people who have care and protection matters in the children's court, around children's court matters. So it's important to distinguish that from family law. It's not actually family law. It's involvement from the Department of Child Protection, so very different to divorce and custody proceedings. It's a relatively new part of law that we've gone into, but we've made pretty good strides in it. So it is good to know that is something that we do as well. So in terms of a referral pathway, we do have the ability to refer clients straight from our website. So you can just go onto the website, go into contact, and it's got a referral form there. You go into the My Client, and it's got that form there. So you can fill that all out, and it has the different options for what their legal matter is, and you can do the referral through that. As I've said throughout this presentation, it's really important to if you are dealing with a client who has any of these issues, to do the referral as quickly as possible. It's important for all our matters, but particularly for the VRO matters, it's really important. But it is helpful to get the referral done quickly. It puts the client at peace of mind. If they have the referral through, we can help them. They can talk to a lawyer, talk about their legal rights, and it does help to put them at ease somewhat throughout the processes. In terms of areas that we don't provide representation on, we do get a lot of people calling up asking us, I've got a tenancy issue or a family law matter, employment matter. Those are all the services which we don't provide advice or representation. And that's purely down to a capacity thing. We just can't offer that quite variety of law. There are many other community legal centres who do offer those services. Tenancy WA offers tenancy advice. There's the Employment Law Centre who offers that, and there are a lot of other low-cost legal services which we do also refer out to if someone does have those issues, and that's the same with applying for restraining orders as well. So if ever there is an issue that perhaps doesn't fall within our scope, we generally do refer to other organisations. So there's the Community Legal WA's database for CLCs, so community legal centres operating representation at low cost or no cost at all. So that's always good to try and point clients in the direction of. Law Access and Legal Aid. Legal Aid obviously mostly for criminal matters, for the more serious criminal matters as well. We'll generally do a referral to them. Aboriginal Legal Service as well. Look, in some circumstances, particularly like family law, there's not really a great deal of free legal advice or representation available. So sometimes the only option is to find for a private lawyer. And the Law Society of WA does have a great find a lawyer function, and they can utilise that as well. So I think you guys did cover a bit of lawyers' duties before, was that correct? In terms of ethical responsibility?
We've been talking about ethical responsibilities of
Yep.
us as mental health workers.
Yeah.
Possibly some overlap.
Yeah, certainly. So there is confidentiality of agreements between a lawyer and a client. So we always need third-party authorisation to talk to mental health professionals from our clients. So if we ever want to discuss the matter with a member of the client's support staff, we do need their authority to do so. And they can revoke that authority at any time. So we can't, if someone does call us up wanting to talk about, a client's matter, we need express authority from the client to discuss it. Ultimately, we've got a duty to the court as well. So anything the client does say to us, if it does come to sentencing and we do need to disclose something to the magistrate, we do have an ultimate duty to the court to do that as well. And it's sometimes quite difficult to balance that with the best interest of the client as well. But yeah, it is important that we uphold that duty to the court. And also always be frank and open with the client. So discussing options, setting out, likely scenarios and potential sentencing. You've always got to inform the client of what's going to be happening going forward. So that's our duties. I think that covers pretty much everything. So if anyone has questions, I know there's a few answered throughout the presentation, but there's probably a lot of information to digest.
What would be the most common offence that you would see?
Most common offence? Well, I think that we get a lot of minor offences, so obstruct or disorderly, disorderly in public, which is essentially, someone causing a racket in public. Police are called, they can charge them with that. But then what happens as a result of that, particularly with clients who are unwell, they'll have the police attend and, often they have, maybe a diagnosis of paranoid schizophrenia. It starts off with a disorderly and then the police do attend and it does kind of escalate and maybe they, obstruct the police officers from arresting them. So then that ends up in becoming an obstruct charge. And then, in some circumstances I've seen that, it starts with something as low as a disorderly and then kind of balloons out to being an assault public officer charge, which is obviously much more serious. But yeah, probably we do get a lot of disorders. We get a lot of possess drug charges, just minor, which I think is kind of a lot of lawyers. There's a lot of smaller drug charges in the courts at the moment, so that's probably most of the criminal law matters. But we do also deal with a variety of different charges. So yeah, it just definitely depends.
In your opinion, with the escalation that sometimes happens
Yep.
with police attendants, do you feel like there's a need for other approaches to that other than police attending those?
Well, I think, yeah, it's a tough one because, obviously the police do need to attend. There is, if there are allegations of someone breaching the law, I think it often comes in the handling of that situation. And perhaps there needs to be, more education in terms of how to deal with someone who is mentally unwell. So I think that's possibly a situation that could be explored more. Because I have had clients like in the past who have been in that exact same situation where it's just kind of, the attendance of the police has triggered something. They do have paranoid schizophrenia, so it's and it's just kind of balloon things out of control. So it probably starts with education, but it definitely helps to have probably mental health professionals dealing with them at that time. But it's never that easy, unfortunately. Yep.
I found that the area you're describing is very narrow. It's very mental health. But I work in a mental institution. Right? With people with family problems, drug problems, homelessness.
Yep.
And marriage, legal issues, child possession, and all this.
Mm-hmm.
How do you differentiate so many?
In terms of how do we differentiate it, or?
People come, mostly they have mental health.
Mm.
That's why they are at that place.
Mm-hmm.
Then they have marriage issues,
Yep.
drug problems. Other things.
Yeah, well, we do work with a good social work team as well, who we try and make referrals where appropriate. If they do have, drug issues or accommodation issues as well, we try and make referrals through that process, and that can then help them out with those issues. Us as lawyers tend to stick only with the law side of it, but yeah, we do have avenues to go down in terms of referral processes for clients who do have, perhaps not legal issues, but social issues. So we can do that as well. All right. Yeah.
So going back to start court,
Yeah.
how long does that process take? So like they do check-ins like
Yeah.
fortnightly on a Thursday. So how long would someone be going through that before they go to sentence?
I think they generally say it's about 6 months. But it is dependent on the client. I've had people be on there for about 9 months, but at minimum, probably around about 6 months and around that kind of time. That generally allows for the Start Court team to, implement all of the program requirements and set them up for that eventual sentencing date. So,
it would take time to like get into those programs.
absolutely,
Results from.
yeah, it does. And like I said, it is really good, a really good avenue to go down. It is quite intensive. Not everyone wants to, check in with court every 2 to 4 weeks. So it isn't for every client. But yeah, I've seen really good outcomes come through the Start Court. So I tend to try and, if the client is wanting to plead guilty to it, there's really no reason not to suggest going through Start Court, particularly if they're looking at like a community-based order as a sentencing outcome anyway, because Start Court's essentially like a community-based order prior to sentencing. And then if they do well on the program, the magistrate takes that into consideration as well, and they could come out looking at like a fine or something like that. So it is really beneficial.
Over 18,
Yes, that's correct. Yep.
the teenagers that are the shoplifting.
No. Yeah, so that would all be dealt with in the children's court. In the children's court, if it's under the age of 18 and they are charged with that, then yeah.
And do you get many like offences like that coming with a stealing problem?
We do get a lot of stealing charges. We obviously don't represent too many people under the age of 18.
With the elder ones, over 18.
We deal with quite a few stealing charges. I wouldn't say it's super prevalent, but I definitely have dealt with that in the past.
Is that like domestic violence?
Some domestic violence, but to be honest, it's not something that we've dealt with too much. I think that might be, I believe legal aid does pick up a lot of that as well. Yeah, so, yep, that's it, yeah.
Thank you.
Not a problem, though.
How long do you typically have to build
It's very dependent on the different matter that we have. If it's like a mental health tribunal matter, sometimes we'll only have that for 2 weeks maybe, or not even that long. So, you know, it's tough to build a rapport with a client, particularly if we only speak to them a couple of times over the phone, and then, you know, I'll always try and meet them in person before their hearing to go through matters. But sometimes you don't have the opportunity to do that if they schedule a mental health tribunal very quickly. Sometimes you only have a couple of days. In terms of our criminal representation, we generally have those for a little bit longer. So if it goes through Star Court, like I said, that's a 6-month period where you get to know the client quite well. But then on the flip side, it could be that you meet the client and they just want to deal with the matter on their first court appearance. So sometimes you take instructions the day of, and you've met them just that day, and they just want to get it done with. So very dependent on what the matter is. Yeah.
Also, I have a question around with the recent cases that have gone through. I think it was like the Victorian courts regarding ECT and the conversation around capacity and what that looks like in mental health tribunals. Does that affect you guys much in how you approach that idea of judgments made about capacity about a person?
Oh yeah, in terms of mental health tribunal, it doesn't come into it too much. Particularly, I think the Victorian system is a bit different to ours, but capacity is one of the criteria that needs to be judged in terms of both inpatient and community treatment orders. So we do try and it's tough to determine capacity, particularly if you're only dealing with the client in a short space of time. But we essentially try and ask them questions to determine, if they do have capacity in terms of treatment making decisions. That can be like, are you wanting to keep taking your medication? Do you think you have a mental health illness? Do you want to keep taking?
So say if someone says, I don't accept my diagnosis, I have a different way of conceptualising my experience. Does that in itself, does that weigh in significantly to the judgment of capacity? Or?
Possibly into the judgment of capacity, it could weigh in. It really depends what if they still think they have a mental illness, but perhaps it's not the same label as the treating team are giving it, then there's arguments to say that that's not indicative that they don't have capacity. And in the way that the Mental Health Act is actually written in terms of the first criteria for both inpatient and community treatment order is that they have a mental illness that requires treatment. It doesn't actually mention that it has to be a diagnosis. It lists a few examples of what a mental illness is, and so that's can be like delusions or disturbances of thought. So it doesn't generally necessarily mean they have to have a formalised diagnosis. Because they can't make the tribunal can't make a ruling on whether someone has a diagnosis. They can obviously agree with the treating team that that is a diagnosis that they have, but they can't make their own assumptions in terms of diagnoses. Yeah. All right. Well, thanks very much for having me. I hope that was informative. Yeah, no problem at all.